is Article 26 of the Constitution of the United Republic of Tanzania, 1977. In my view, the Article 26 has received somewhat superficial and mundane treatment, and rather very technical treatment. Of course, it has worked so far and continues serving the purpose. But I want to suggest to you that Article 21 is a very profound article of the Constitution with deep meaning. So I will start with a kind of jurisprudential treatment of Article 26. Please bear with me, those who are not interested in jurisprudence, but I think it is important for us to apply jurisprudence to the understanding of our Constitution. So my presentation today is divided in 4 parts. I'll first discuss the jurisprudential treatment of Article 26. Then I will discuss the amendment of Basic Rights and Duties Enforcement Act, amendment which was made by Return Laws Miscellaneous Amendment of 2020, Act number 3. Henceforth, I will use the word Bradea and Bradea Amendment. Then in my 3rd part, I will discuss the question of immunity. And in the 4th part, I will end by discussing public interest litigation, or PIL, and its constituency. Specifically the question, who is the public in the public interest litigation? So these are the 4 parts, and I hope I can complete my presentation in the time allocated to me. But if I exceed 5 or 10 minutes, please. Now, let me ask once again, am I being heard? Otherwise, there's no point in going on. Can you hear me?
Yes.
Okay. Okay, so let me start with part 1 of my presentation. Article 26 appears in part 3 of chapter 1 of the Constitution. And part 3, as we know, stipulates fundamental rights and duties. Article 26 has 2 sub-articles. Sub-article 1 says every person has to obey the Constitution and the laws of the land. Every person duty to obey the Constitution and the laws of the land. So clearly, sub-article 1 is talking about duty. Then sub-article 2, in the same breath, in the same article says, every person has the right to take legal action to ensure the protection of the Constitution and laws of the land. Now, I would like you to underscore that Article 26, in the same breath, talks about duty and right. My next question is, What is the right in sub-article 2? It is the right to take legal action. It is the right to take legal action. Why? To ensure protection of the Constitution. So the right specified in sub-article 2 of Article 26 is not a right to protect the Constitution. It is a right to take action to ensure the protection of the Constitution. Even in ordinary language, we don't say, I have a right to protect. You say, I have a duty to protect. For example, you don't say, I have a right to protect a drowning child. No. You say, I have a duty to protect or rescue a drowning child. So I want to suggest to you that the notion of duty is embedded in Article 26.2. The notion of duty is embedded in Article 26.2. One, I have a right to take legal action to ensure protection of the Constitution. And two, I have a duty to protect the Constitution. Both right and duty are embedded in sub-article 2 of Article 26. This is important because it is not sufficient to talk about right, because it is a right to legal action, but there is also a duty of every person to ensure protection of the Constitution. I would go further and suggest that Article 26 should be read together with Article 29, sub-article 1. In my view, Article 29, sub-article 1 is another very profound article in the Constitution of the United Republic, which I believe has not been deployed sufficiently by our litigators. What does it say? Article 29, sub-article 1 is double-barreled. It has two limbs. First, every person in the United Republic of Tanzania has a right to enjoy the fruits of his or her fundamental right. Article 29, sub-article 1 has two limbs. The first limb says, every person in the United Republic of Tanzania has a right to enjoy the fruits of his or her fundamental rights. So it is right to rights. It is not sufficient that you have been given a right by the Constitution. Because if we talk about simply having a right or possessing a right, then it's a one-off situation. It is abstract. But Article 29.1 makes it very clear that in fact it's a continuous right to enjoy your fundamental rights. So it is continuous. And I think that is more important in practice. It's not sufficient to have a right, but it's also important to enjoy those rights in practice. So, as I said, Article 29.1 gives you a right to enjoy your fundamental rights on a continuous basis. Anything that breaches my enjoyment of my rights or obstructs or diminishes the enjoyment of my rights is in violation of Article 29(1). And I have a cause of action to redress it. So 29(1) actually gives you a basis for a petition in which you can found a cause of action, because your right to enjoy your rights has been either abbreviated or obstructed or diminished or in any way constrained. Now, I wonder how many times have our lawyers, advocates, used Article 29(1) to found a cause of action. I haven't seen any case which is squarely based on 29(1). Maybe there have been cases. If so, it will be pointed out in our discussion. Nor have I noticed any jurisprudential writing by our academic lawyers in Article 29(1). Now, the second limb of 29(1) says in effect that every person in the United Republic of Tanzania has a right to enjoy the benefits or the outcome or results. The word used in Kiswahili is matokeo, of every person fulfilling his or her duty to society. Now that is very interesting in my view. So when a person fulfills his or her duty, every person in the United Republic of Tanzania has the right to enjoy the outcome, the benefits of the fulfillment of that duty. Now, when you say that every person has a right to enjoy the fruit or the benefits of someone performing his or her duty, what are you saying? What do you mean by every person? By every person, obviously it means public. So every member of the public has a right to enjoy the benefits, the outcome, or the results of every person observing, performing, fulfilling his or her duty. So every person to enjoy the outcome of fulfillment of a duty by every person means every member of the public. Hence, we are talking about public interest litigation. It is the interest of the public to litigate, for someone to litigate, to ensure that he or she carries out his or her duty to ensure protection of the Constitution. The outcome of that litigation is in the interest of the public. Once you read Article 26, 2, together with Article 29(1), we get a very sound constitutional basis for public interest litigation. In other words, we did not have to import PIL from other jurisdictions like India. We already have it in our constitution since 1984, when the Bill of Rights and Duties was inserted in the constitution. The late Judge Luga Kingira, in the leading High Court case of Mtikila, which is reported in 1995, Tanzania Law Reports, said it so much. And although he talks about the duty to protect the Constitution, he did not explain, as far as I can remember in the case, how did he arrive at the conclusion that every person has a duty to protect the Constitution. But he does talk about duty to protect the Constitution, and therefore concluded that Article 26, Sub-Article 2, gives a standing to any person who takes legal action to ensure protection of the Constitution. And since then, since 1995, when the tequila was decided, for 25 years, we have had a long line of authorities, both from the High Court as well as the Court of Appeal, recognizing, acknowledging public interest litigation in Tanzania. To the best of my knowledge, it has never been challenged. The last case that I read on it, which recognizes PIL, is the case of Indonesia. So for 25 years, we have a solid, long line of authorities which have recognized PIL. Now let me come to the second part of my presentation. And this is the amendment of Bradea, the Act number 3 of 2020. In 2020, Bradea was amended. And straight away, my conclusion of that amendment is that it sought to abolish PIL. The amendment, the intention, and the reading, close reading of the amendment is to try to abolish PIL. How does it do it? What does the amendment say? First, it renumbers Section 4 of Bradea as subsection 1 and adds new 4 subsections. For our present discussion, it is subsections 2 and 3 which are relevant. That is to say, subsections 2 and 3 of Bradea, which were inserted by the amendment, are relevant. Subsection 1 of section 4, as it stands after the amendment, is almost a verbatim English translation of Article 30, sub-article 3 of the Constitution. As you know, Article 30, sub-article 3 gives a person who is alleging a breach of his or her constitutional right in relation to him or her, gives a right to file a petition in the High Court to redress the wrong or the harm done to him or her. Subsection 4, subsection 1 of section 4 of Bradea more or less repeats that. Now the new subsection 2, which is added by the amendment, stipulates that the petition under subsection 1 must be accompanied by affidavit stating the extent to which the contravention has affected such person personally. In other words, the affidavit must state the extent of the harm done to the petitioner personally. On the face of it, subsection 2 looks innocuous, although it is somewhat strange. How do you state in your affidavit the extent of the harm? 20%, 30%, 40%? What is it? In any case, in practice, as advocates know, it is in the argument, in the course of the argument before the court, that you show to the court the extent of the harm done by the impugned provision of law that you are bringing before the court. And the extent of the damage or harm is assessed by the court. Be that as it may, the real crunch lies in subsection 3, which has again been amended, which has been added by the amendment. And I think it's important. Let me read that out. Subsection 3 of Bradea, after amendment, reads, for avoidance of doubt, a person exercising the right provided for under Article 26(2) of the Constitution shall abide with the provisions of Article 33 of the Constitution. For the avoidance of doubt, a person exercising the right provided under Article 26, subarticle 2 of the Constitution shall abide with the provisions of Article 33 of the Constitution. Article 33, as I've already said, gives a standing to the person who has been harmed, a locus to the person who has been harmed to file a petition in court. This subsection says that if you are filing a petition under 26(2), you have to abide by the conditions of Article 30, subarticle 3. And what does the for the avoidance of doubt mean here? In case, on reading subsection 2, you have any doubt, that doubt is cleared by subarticle 3. So whether you file a petition under 26(2) or 33, you must abide by the conditions of 33, which means you must demonstrate that you have been personally harmed. What is the implication of this? Whether you file a petition under 26(2) or 33, it throws us 3 and tends to subsection 1 of Bradea. What is the implication of that amendment? 1, Article 26(2), in my view, is qualified by Article 30, subarticle 3, by virtue of that amendment. 2, the amendment almost conflates 26(2) and 33. Whereas previously, before the amendment, you had 2 independent avenues or sources of locus standi to access justice in case of contravention of constitutional rights. Now you have only one, which is Article 30, subarticle 3. So the amendment conflates 26(2) with 33, and in the process closes the avenue, closes 2 avenues into one. 3, the implication of the amendment is that 26(2) is subjected to or subordinated to Article 33. Whereas the plain reading of these two articles is clearly that these two articles are independent. Neither one is subordinate to the other, nor are they interdependent. They are independent articles. And that was the holding in Tequila case. That Article 26(2) and 33 are independent. They're not related to each other. And they provide two sources of locus standi. And this, since 1995, when Tequila was decided, has been upheld by both the High Court and the Court of Appeal. Now, this amendment makes 26(2) dependent on 33. In others, it destroys the independence of the two articles of a constitution. So my conclusion is that the amendment results in two things. One, it surreptitiously, secretly, through the back door, amends the Constitution, which of course is unconstitutional. Because if the intention was to amend the Constitution and make 26(2) subject to 33, then the proper procedure would have been to amend the Constitution under, I believe, Article 98 of the Constitution. But of course, that was not done. For reasons which are obvious, it would have been politically very embarrassing to do that. So the draftsperson thought that he was very clever by smuggling in the amendment of the Constitution by an ordinary piece of legislation. Second, the amendment, in my view, overrules the long line of High Court and Court of Appeal authorities and decisions. Since Tequila, the line of authority which have stood the test of time for 25 years. This amendment of ordinary legislation overrules these authorities, which to say the least is never done by self-respecting legislature. It is very rarely that the legislature passes a piece of legislation to overrule the decision of a court of law. It happened very frequently in apartheid South Africa, where the South African Parliament during that period would pass a legislation to overrule certain decisions of the court which they did not like. In Tanzania, as far as I know, there has been only one such piece of legislation. And this happened, I believe in 1962 or 1963, where the East African Court of Appeal awarded an enormous amount of compensation to Chief Mariale, and the chiefdom was abolished. The Tanganyika legislature at that point passed legislation to overrule that decision. But that has happened only once, as far as I know. Now, I understand that advocates, public-spirited advocates have tried a number of petitions to challenge in the High Court this amendment. Hello? Can you hear me? Sorry? Okay, I'm going on. But as far as I know, none has succeeded. There's one still pending, and we hope that it will have a better outcome. The only petition in inverted commas, which has succeeded, was in a moot court filed in the High Court of Zanzibar during the training of East African lawyers. Maybe the law students, maybe the students of the Law School of Tanzania and the faculty may want to get access to that judgment, which was written by a leading judge of the High Court of Tanzania, and in my view, it's a very good judgment, where the judge declared the amendment as unconstitutional. Now, to wind up that part of my presentation, I'm aware that the Attorney General in such petitions has put forward twofold defense. One is that the amendment does not amend the Constitution. It only provides a better procedure for the implementation of 26(2). In my view, this is a very weak argument. First, the amendment is clearly not procedural. It is substantive, as I demonstrated. An amendment that takes away a pre-existing right cannot be called procedural. It is substantive. And secondly, why provide a procedure after 25 years? Because 26(2) was operational for 25 years. Why did you find a need to provide a procedure after 25 years? The second defense that I have constantly seen filed by AG is that the amendment is meant to weed out frivolous and vexatious PIL. But the problem with that defense is Bradea already provides in section 8, subsection, I believe it's 2 or 4, where the High Court can reject a frivolous, vexatious petition. So then the amendment becomes superfluous. Because it's already provisioned in law where the High Court, and in this case, even a single judge, has jurisdiction to be adjudged to be frivolous or vexatious. Now, let me come to the question on sovereign immunity, and I'll show why I'm calling it so. Subsection 4 of section 4 of Bradea amendment stipulates that the president, vice president, prime minister, speaker, deputy speaker, or chief justice cannot be named in a petition. Any redress is sought against these office holders. The petition must be filed against the Attorney General and not the holders of this constitutional. A similar amendment has been inserted in the law reform which, as you might know, provides for prerogative orders under judicial review application, which means that if you file a judicial review application where you are challenging the act or omission of the office holders, named office holders, you cannot file the application against them. Instead, you have to file. In my view, this provision confusion between proper party and a necessary party. I'll explain. If, for example, you against the wrong done by the president, your cause of action is that the president has either abused or exceeded his power under the Constitution. The proper party to seek redress against is, of course, the president. And the Attorney General will be joined as a necessary party, because in all public law litigation, Attorney General is the one who represents government officers and institutions. The Attorney General is a necessary party. But the proper party, which has to be the one who is the wrongdoer, undoubtedly. If you file such a petition, the Attorney General will represent the president. But the president has to be a party. So that's the proper party. Now, if you don't make the president a party, you get an absurd situation. You file a petition against AG. In the text of the petition, you allege the president has abused his powers under the Constitution, but the alleged transgressor is not before the court. The party before the court is the Attorney General, who is not the transgressor, while the transgressor is not before the court. No respectable court will entertain such a petition. Without further ado, it is simply dismiss such a petition. Because you cannot make an order against a party which is not before the court, which has not been given a hearing. Let me quickly give you a concrete illustration. Many years ago, if I remember correctly, a person who had petitioned to be enrolled as an advocate was denied enrollment by the Chief Justice without being given a hearing. The aggrieved person filed a judicial review application against the Chief Justice and joining the Attorney General as a necessary party. Now, if the situation was after this amendment, you would not be able to file a judicial review application against the president. You'll file it against the Attorney General. But the Attorney General has not denied the person to be enrolled. So how does it work? The conclusion that I make, that if you cannot make a named officer accountable for his public wrong, if you cannot take a lawful action against the named officer for the alleged public wrong, then you are in effect giving such a person immunity. And it amounts to sovereign immunity. In fact, that person becomes above the law. Only in monarchies you have such a thing, where those of you who study your legal method well will know. You are taught that the king does no wrong, and the king cannot be dragged into his own court. Such immunity exists, as I said, only in monarchies. That's why I'm calling it a sovereign immunity, but not in democratic republics. There's no such thing as sovereign immunity in republics. All constitutional office bearers constitutional office holders, right from the president, are subject to law, are governed by law. They don't have immunity against breach of the Constitution and the law. I come now to my final part, which I have called PIL and its constituency. Briefly, who is the public in PIL? In the long public interest litigation filed in our courts by advocates, sometimes in their own name, I have a feeling the public has not been chosen strategically. And lately, PIL also became some kind of a campaigning tool for political parties. While advocates were doing a good job, but they did not have a large section of the public behind them. In other words, they lacked public legitimacy. It's only the educated classes and social media celebrities who applauded. But that is not sufficient in my view. When the large section of the public, in our case constituted by the downtrodden, do not have any idea of what is going on in courts. Now, if you do not have the support, I submit that you are fighting a lost cause. And I'll end by giving you a quick illustration on bail and bail conditions. A number of public interest litigation have been filed against the law on unbailable offenses, example, the Money Laundering Act, which is to be applauded. But in the same court where you appear for your petition to be heard, you find hundreds of people who every day lose their freedom because they're unable to get bail, even in bailable offenses, for the simple reason that they cannot fulfill harsh conditions of bail that the courts impose at the behest of prosecutors. I have the impression, and you may tell if I'm wrong, that in our magistrate's court, whatever the prosecutor asks for the conditions to be imposed are more or less accepted by the magistrates. And the conditions are so harsh that ordinary people cannot fulfill them because they cannot afford the security of money or put in the titles of real property because they don't have real property, and therefore invariably they lose their freedom and are remanded in custody, in Mahabusu. In other words, the person fails to enjoy his or her freedom simply because that person is impecunious or doesn't have real property. Now, is that constitutional? Is that constitutional? I believe that such practice of imposing harsh conditions to be able to get bail is unconstitutional because it obstructs you from enjoying your freedoms. And that is purely because you don't have the capacity to afford to fulfill the conditions of bail. If you take the analogy of the Janabo case, which required the petitioner in an election petition to deposit 5 million shillings, was unconstitutional because you are denying access to the court. I think that analogy can be used perfectly for such a case. And yet I have not seen any public interest litigation filed trying to declare such conditions unconstitutional. Now, if you did file such a PIL, obviously it will attract large section of the public who lose their freedom every day in courts because they cannot fulfill bail conditions. Dr. Moderator, I finish with that and look forward to our discussion. Asante sana.
So much for the discussion and the welcome questions. Any contribution you have?
Nauliza kwamba katika maelezo mlizungumza kwamba kuna mahakama ama maamuzi ya mahakama kuu iliyobatilisha hiyo amendment ya namba 3 ya mwaka 2020. Katika maelezo kuonyesha kwamba mabadiliko aliyofanya yanaathiri public cases. Sasa ningeomba moja ufafanue ndio katika hichi kama tunaweza tukapata access ya
He was asking that there was an authority that he cited from Zanzibar regarding public interest litigation, and he wanted more clarification that authority allowed. Yes, the situation of public interest litigation in mainland. That's how I got this question. The authority mentioned, the case mentioned is Tanzania. We also welcome any people who are online. You're welcome to ask questions. You can write your questions in the chat box, and our team will also try to answer those questions. I think even to that, Professor, we want to thank you. If there are any other questions, since you're still online, we'll discuss further and we'll continue to enrich our knowledge. With that said, I would like to welcome, we start with yes, yes. I would like to welcome Judge Donald Makarapa. He's a renowned human rights guru, and he's also a part-time lecturer here at the Law of Tanzania. Welcome.
My answer is very simple. After the erudite words from the professor, I had the opportunity to be one of the students, but later we were teaching together in the Judiciary department in the University of where I stayed for 12 years traveling to class. Now, I'm giving the perspective on public interest litigation from a retired judge, but using my experience at the bench dealing with human rights. The good professor, as usual, side has given you the ABC of public interest litigation. But I think there is a problem. People associate the word public interest litigation with activism. The moment you mention the word public interest litigation, some good people start running away. And I think that's why most lawyers also shy away from participating in public interest litigation. But what they forget is that also lawyers, you and I, we are part of the problem. The only thing is, what kind of interest have you shared with the council public interest? Now, there is a South African judge, it's called Agnes Sash, and he was among the 11 judges of the Constitutional Court of South Africa, and he was also a former freedom fighter. And actually, he lost one of his arms in a car bomb week, where he was participating in the declaration of South Africa. And in the lecture he gave in London School of Economics, he came up with some prophets. And he said the 19th century was a century in which the executive took command of the state. 19th century. The 20th century was the century in which Parliament took command of the executive. Now, what about the 21st century? He said the following about the 21st century. The 21st century will be a century in which the judiciary secures basic rules and processes, the values of functioning of both Parliament and the executive. Now, most of you are sitting here. Is this thing happening? You see the judiciary commanding Parliament and the executive. You heard what Professor was saying, that now there is a tendency of Parliament passing law to overrule court decisions. This is what happened for the past 12 years. Just with the strike of a pen, you overrule the judiciary. So now, what is not happening in the 21st century is exactly what happened after the amendment of the. Now that is what I wanted to make you understand, that the prophecy was made by none other than just such, but what is happening on the ground is completely different. Of course, the public interest litigation issue, as you can see, and from what the professor has said, is about taking legal action. And you saw how to take legal action under our laws after the amendment. Now, the action you are taking, you have to take it in a court of law for the enforcement of public interest or general interest. Now, there is a problem, and the professor tried to explain, but I will amplify on that. If you ask yourself, who is the public, as the professor was asking, how do you identify the public? Because in most public interest litigation you find individual advocates or leaders of civil society organizations. Now, where do you see the public? It's different from class action. Now, that is the first problem. When people fail to blockade the public, then they start making some negative sentiments about public interest. Now, I'll give you an example. The Rebecca Yumi case, she was protecting the rights of young children getting married before that. Now, it was only one person, but I just was talking about the public interest of all the children below 18 years. You see the public interest how it happens. We don't hold a meeting to get the interest. It's just to have legal action taken on a matter which is of general public interest. And this is what distinguishes public interest litigation from other types of private interest. That we have the public at the core of the litigation. The second theme is the public interest itself. You remember there was a former judge of England who said the public is an unruled horse. It can take you anywhere. That's why it becomes a little bit problematic to define the interest. Now, what is the interest of the public? Now, if you want to know the interest of the public, it is used as a platform for advocacy. And this is what distinguishes public interest litigation from all types of litigation. It's a tool for advocacy, which means even if you are not successful in your case, you have already raised the awareness among the public on a certain public interest issue. It's a learning exercise. Now, the litigation act, this is why it becomes problematic, because you take a social issue and you frame it as a rights violation. And in order to know whether this is a rights violation, you must have a legal framework. Now, in order to be able to analyze as an advocate how to take a case of public interest. There is one person called Charles Eddy. He wrote a book called The Rights Revolution, Lawyers, Activists, and Supreme Courts in Comparative Perspective, and he wrote it in 1998. He came up with a theory of 4 conditions which must exist in order for public interest litigation. The first one, there must be an existing rights framework. Now, the rights framework means either the Constitution or a statute. And as you can see in Tanzania, we have a Constitution which provides for the litigation cause of action, but we have a statute which abrogates that kind of right. So we must have an existing right. Now, as an advocate, you have to ask yourself, what kind of a legal framework exists for me to be able to bring a case in a court of law? Now, the second condition to be made is that there must be an independent and knowledgeable judiciary. Because the other thing is that judiciary must be robust, impartial, and with integrity. Now, of course, it takes into account it's not only according to the judiciary to be impartial, robust, knowledgeable, also the advocates who are bringing cases before the court must be knowledgeable. Now, what does that mean? Of course, when I was sitting on the bench, it was almost a taboo not to say that judges do not know the law. Because how will you become a judge who do not know the law? Because those who are appearing before you must also are taken also to know the law. But I can assure you, most advocates who appear before courts of court, some of them know part of the law, not the whole law. And you spend a good time at the university knowing the law. You come out knowing it personally. Come to the law school, then you realize that even that little I knew at the university is no longer in my head. And that's why they say it takes practice to make it perfect. Here you are only getting your certificate so that you can go and perfect your practice. And some of the things you learn here, you may die even without practice. So, and to be safe, I think in public interest litigation, you are going to practice what you did not learn at the university. That is the problem. Now, how do you learn? You have to take a case. Lawyers learn through doing it. Now, the third condition, there must be civil society organizations with the capacity to frame social problems as rights violations and to litigate. Now, watch my words. We don't talk about advocates, we're talking about civil society organizations. Because advocates who take up public interest litigation are what we call social advocates. They are part of civil society. Now they have that extra knowledge of framing social problems as legal problems. And that is what the professor was saying. You go to the provision, any lawyer, the first case you ask yourself is there a cause of action? Has any right to be violated? Does the court have jurisdiction? What kind of remedy am I going to ask for? Because at the end of the day, you must have a remedy. Now, that is the third test when you want to bring this public interest litigation. The fourth one, and this is extremely crucial, there must be a network to support and liberate the opportunities presented by litigation. And actually insist here that in public interest litigation, it's not a matter of going solo. You need a sectoral approach because you need different types of expertise in such a problem. For example, as you know, in Tanzania, we do not have social and economic rights as part of our constitutional bill of rights. But you can have a lot of other problems which touch on socio-economic rights. For example, denial of clean water. How do you frame it as a legal issue if there is no provision in the constitution? That is very quick. So you have to go to the other statutes which provide that kind of law. Now, public interest litigation by its nature deals with rights which are enjoyed by everybody, not persons. Like, for example, air pollution. You cannot say that me, because I'm living in an air pollution, I'm not affected by pollution. Pollution affects all of us. So by public interest investigation, when you bring a case on environmental pollution, you are talking about the larger interest in the proposal in which you are also involved. Now that is what I should insist that the multi-sector approach is critical, because we have seen over time that cases of public litigation be taken as if it's an individual effort. And I have always been telling lawyers that they should bring these cases as part of a team. Now, a good strategy in bringing a public interest litigation is to have a team of players. You have lawyers, you have social scientists, you have everybody who is an expert in the area in which you are engaged in. Now, that is what I have to say. My last point is that as lawyers, as you know, public interest litigation does not only involve filing cases in our national courts. It involves filing cases in the regional mechanism, one of which is the East African Court of Justice and the African Court of Human Rights, Human Rights. Of course, another mechanism is the African Commission of Human and People's Rights. But most lawyers do forget that within our national system, there is a tribunal on human rights located within the Commission for Human Rights and Good Governance. I had the opportunity also of serving as a commissioner in that commission for almost 5.5 years. And we had a litigation conducted by that tribunal, the most important of which was the Rumba case, where some people in the rural area, and rural area is becoming also very famous because we have another small society. And they still have affiliates appropriately African organizations. Now, in that case, number of villagers' houses were set on fire by order of the area commission. See, so they had to file a case in the commission for it. So the commission appointed a tribunal headed by the former chairperson, Honorable the late Justice Sanga, and they heard the case and determined that those people had to be compensated. So they were awarded almost 890 million Tanzanian shillings in compensation. There was some problem in enforcement, but actually now I'm told the government has started paying out the compensation. That is my last state, that for a lawyer, when you go to court, public interest litigation, another condition which you have to fulfill is how to enforce the decision. Right? So that is the most disappointing part. That you may come up with a very good court case, but the enforcement can be also a nightmare. Now, as you know, the basic problem lies in our constitution, and that process is about five, where they say in case you succeed in impugning the law and act, the court cannot declare immediately that it is unconstitutional. You have to give time to the person who injured your right to correct. Now, I've always been saying that lawyers must be strategic. It's not only if you see that litigation cannot work, you must resort to what we call alternative dispute. There are some areas where you can engage with the violators on mediation, and then you can sort out the matter, the necessity of going to court. But if you find that you have to go to court, then you can resort to it as a final or last resort. In our constitution, the constitution says that the courts are the ones that are with the authority to say what is final in respect of rights, which means there are other institutions which can deal with rights, but the courts should be of last resort. So most public interest lawyers do not need to rush to court as a first instance. You have to try other evidence. Now, in our constitution also, under 107, about AEP, it talks about alternative dispute resolution. It's a matter of the constitution, but unfortunately, not so many people take it up that strategy of using that alternative dispute resolution and the way of enforcing their human rights. And actually, in public investigation, if you use alternative dispute resolution, it may work very well because it involves the participation of the. So in a nutshell, that's what I wanted to emphasize, because the good professor has done a very good discussion on the. Now, of course, finally, as you will be going to practice, you'll be interested to know what is the future of public investigation. The future of public investigation lies in the hands of authority, including Parliament. Hopefully, if they are convinced or lobby, they can change that law. Secondly, it also lies in our courts. The courts to be robust and to interpret the law, to defend the Constitution. And now we have seen what the High Court decides, the Court of Appeal might decide otherwise. But what all the High Court of Appeal says can actually be allocated by the European States. Now, in other countries like Ghana, in order to avoid this problem of hide and seek, people not enforcing decisions of courts, they put it in their constitution, which is, I think it's the one constitution, that there is a criminal offense if you do not fulfill your duty under the constitution. So they criminalize the action of the executive not abiding by court decision when it comes to human rights. Now, I said, I don't know. And we don't want to go there. But actually, that's why I've been saying that we should engage in the dialogue, because those are human beings, they can be convinced, and lawyers will assist by making them understand the import and the reach of our profession. Thank you.
Thank you, Mr. Baraka. I think we have now a bigger insight from what the professor has said, the amendments which were done by Madina. The state was that it was a pluralist amendment to try amending the constitution through backdoor, and also the difficulties that senators of the public have in understanding the legal procedures, especially when it comes to bail, that conditions for bail seem to be very difficult and they usually make people not understand and their rights to be denied. But also, Abdullah discussed as to the take of public investigation, how we can tackle public investigation. It has to be a right, it has to be a framework. Okay? We also have to understand the cause of action. But most importantly, we have to understand that public investigation does not rest only for one person. In order to be successful, we have to create a team, an network. She talked about the CSO. What is important is that there are many non-governmental institutions that actually support public investigation. So, if you as future lawyers see a problem in society, you prosecute yourself, and you use that avenue to tackle public investigation. But most of all, public investigation also acts as awareness creation. Okay, so that is something that you have to understand. If you don't succeed, still there's an impact that you have left behind in the society, in the community. I welcome, but I think, do you have any questions before we proceed? Any clarification? Yes.
Okay, to me, I just have a comment, views or comments toward the whole course of public interest litigation. So in most cases, when you're talking about public interest litigation, we don't talk about how we don't intend to cover a certain group of people, probably children, maybe parents, or maybe a specific group of people. But however, we thought that the practicability part of it is like, okay, after the liberation now, there may be the law and constitution, what's the way forward? Because at the end, you can declare the law and constitution, but are the people which the law tends to be to cover, are they ready to comply with? For example, maybe for example, the case of a bill, they state that they want to protect the child, the child below the age of 15, but are the parents, the child, are they ready to comply with the law? Because sometimes you might be fighting for the institutional person, but however, the group of people, doesn't see the specific protection as protection. They see it in other way, like violation of violation of rights. For example, maybe a Sukuma somewhere in Bayani. For them to be married, a daughter to be married, regardless of the age, is a prestige. And by the way, even the dowry stuff, they are paid men. So when you're talking about the amendment, are we really looking about the interest of the people? Because in the end, no matter what the amendment is going to make, however, if the people aren't ready to comply, in the end, it's going to be a sexual complaint. Because some people, you tend to protect their rights, but they don't see it as a protection. They see it as their rights. So that's what I mean.
I think the last so many people now if you go to court to declare. So that's why I say the public interest there is a specific group which are affected, but it's part of the society. Now, like the Rebecca Young case, you know, it involves also a question of social attitude and cultural background of society. You cannot tell people think you're like all over the country. I'll tell you one thing, we have a law of marriage act, which is one of the laws which is more in the breach than respect. Like, of course, the school, there's a child there. You have very funny cases, people getting married, and all the parents see that's okay, except us who went to school with the numbers in our heads. Then they ask me, how do you define a girl? So then they define if she's already mature. Now, what is maturity? And the Shabbat, that is the definition. Now, actually, that's why I keep on saying, if you look at the international law, the Convention on the Rights of the Child, they didn't give a concrete definition of who is a child. They left it upon nations to determine, because otherwise, the Islamic countries do not have acceded to that convention. Because for most Muslims, if you are 9 and you are mature, don't talk about it. School can come in. But actually, what is the larger public interest? That's why I say most public interest lawyers must frame a social problem as a legal issue. Now you have to use what we call problem tree analysis. Problem tree analysis, unatafuta mzizi wa. Now, sometimes I say people use the Karumekenga note. Then a lot of change of things are according to the Robin. Now, if you don't take a girl to school, what will happen? You have very stupid mothers. If you have a lot of stupid mothers, you will be very unhealthy society. Because you don't know how to care for their children, and you have a lot of ignorant children. So there is a whole lot of things which you must explain to the people to understand. What most people in Sukuma, they are satisfied when they have a lot of cows. Then that is what is important. Now this is thing we call the LAD. What is the LAD? How many cows in an LAD? Because if you go to the Sukuma, they ask you how many cows do you own? You say I have a certificate of LAD. And then they say, what is this LAD? Can it give you milk? Can it give you white? Because there in Sukuma, depending on your color of your skin, if you are a little bit light skin, the number of cows you get 40. It's like you're buying a Scania. Now that is the problem. That's how do we as public interest lawyers can frame social problem in a legal issue and then go to court. But I wanted also to tell you about somebody called Justice Bagwat. Justice Bagwat is a very renowned judge. Of course, he died. Him and Krishna, they are the ones who actually were pioneers in public interest litigation. They say the three conditions for public interest litigation. First, there must be an injury. That's not one of it. As a public, I call it not individual, because the individual can go on a tort case, but as a public, for a large public. For example, you remember the demolition exercise along Morogoro Road. Affected everybody, I call it. So it was a right issue. How do you frame it? Now the second one, that person who is called a victim, who has been injured, has no means of accessing the courts. Now, we're not talking about people who can access courts. We're talking about poor people. Your father and mother in the village will now contribute to it with them so much. Most of you are in most of secondary. By your education, you are going to liberate not only your family, but the larger society. So how do you now use your knowledge up? The third one, but I want to say, lazima waweze kwenda wapate redress, because it doesn't make sense if you go to a court of law and you get that redress. But a redress must be effective and you can implement it. So that is the third problem I told you about our courts. We have access to court, we can declare it a constitution, but later, what is the redress? And actually, one of the biggest problems you are having is to be able to enforce decisions which arise from public interest litigation. Now, the last thing, a judge in Kenya warned that if lawyers are not careful, people might use public interest litigation to carry forward their political interest. And lawyers must be very careful. Ni karibu na uchaguzi, mtu anaibuka huko anatafuta watu wanaona mahakamani ili apate limelight. So lawyers have to be very careful. Is this a personal interest or a public? So someone can use the public interest to carry forward his public political interest. Now, Masiasa anapenda kweli. He is at the forefront, although he's not the victim. Now you ask him, have you been injured? No. Have you accessed the court? Yes, but I cannot on my own. Now, what are you seeking from the court? Now, there you don't get any answer because they are not being checked. So if you ask those questions, you don't get the answer. That's not a public interest litigation. It's not, that's not informed because you can use private litigation to achieve your personal interest. But if you use public interest, you must achieve the larger public. And that's why I say lawyers who engage in public interest should not have money as their interest. They should have the public as their interest. As lawyers also, I advise them not to use public interest litigation for IDD. There are lawyers who go around boasting and say, you know, I'm the one who conducted the case in you. So you ask him, are you? No, but I'm the lawyer. So you finish your job. Why you something? Utafanya kazi taratibu ili tukikomboa nchi tunajua tunakomboa. Haiko na mimi bali Yesu alikuwa anasikia kwamba tutakomboa.
Thank you very much. But also to just add a notion to that change that are made for hand in hand yes, it is good to get those milestones, but it's also very important for the civil society to work towards empowering the public. And because you cannot only aim at empowering only those who are affected, everybody needs to understand the impact of changes that are happening in society. There was a question, this professor is shaking. Is still alive? There was a question directed to him.
Hello, yes, I'm there.
Yes, there is a question
Yes.
from our participants, and it reads, what is the way forward for public interest litigation in Tanzania, according to your view?
Okay. If I understand the question, is what's the way forward for PIL in Tanzania, right?
Yes.
Okay, my short answer would be that if we are to reinstall public interest litigation after the amendment, we need to mobilize the public. This is extremely important. We need to mobilize the public. And the only way we can mobilize the public is by building our own credibility. And therefore, what Judge Bakaramba was saying in his second intervention is extremely important. Public interest lawyers, in my view, must have two fundamental qualities to be able to credibility with the public. These are one, commitment, and two, competency. Commitment to the cause of freedom and the struggle against tyranny. Let us not forget that our public, large sections of it, in the urban areas and villages, are laboring against great amounts of tyranny. Their freedoms and rights are tempered with left, right, and center. You must have witnessed how in public meetings, some regional commissioners and district commissioners simply order the police to arrest a person for asking a particular question or for something else. So, first and foremost quality of a public interest lawyer is to have commitment, must be committed to fight for the cause of freedom, for the public, for large sections of the public. And the public here means, as I said, those who are oppressed. Two, competency. It's extremely important that public interest lawyers must be competent in terms of the profession, because public interest litigation is not a ground for training. As many young lawyers, I'm not saying all, but many young lawyers undertake PIL for the purpose of gaining experience. And once they have got it, they abandon PIL to do business. That is not a committed PIL, public interest lawyer. It's not a ground for training, nor is it a ground for gaining celebrity status. There's another important point to keep in mind, because if you do so, then you lose credibility with the people. You lose credibility with the people. So I think these are two fundamental qualities of a public interest lawyer: competency and commitment. And therefore, I'm repeating what I said. The public has to mobilize side by side with court cases. You have to find ways of publicizing and bringing into public domain what Judge Bakaramba was saying, social problems, which you convert into legal issues. Then only you can gain credibility. And it will be the public who will defend the process of PIL. Without that, we cannot really move forward. Thank you.
Thank you, Professor. Credibility and competency. We welcome right now Onesmo to give us insight on impact and procedures for public participation.
Good evening, Ray. Are you tired? Thank you, Professor Chief, Makaramba, Professor for the wonderful session that has started. Now, quickly, I will just go on to issue. First of all, I will be summarizing the impacts of the recent amendments and can be into various clusters. For instance, the impact of the Constitution of which actually I will not give much. This was Chief Judge Makaramba, President. There's also an impact on human rights in general, an impact on civil society, human rights defenders, and an impact to the public, and even to the international community, given the fact that Tanzania is part of various regional international human rights movements that requires the enjoyment and enforcement of human rights to be in line with various regional international standards. Now, in the Constitution, as what our professor said, the amendments that were done last year quickly violated the Constitution, the provision of the Constitution, or amended the Constitution through the backdoor procedure. Just by taking the two provisions, 26(2) and 33, and making them to be one or depending on each other. Therefore, generally, the opportunities for the rights and duties of this citizen, of our people in Tanzania to defend the Constitution or to be part of the process of defending the Constitution or protecting the Constitution has been already eroded extensively. So now, that room, the wider room that existed of people of this country, civil society, and whoever to use the Constitution provisions to defend whatever sort of rights within the Constitution or other laws of this nation has been significantly eroded. So that can be one of the impacts to the Constitution, among other that have been already explained. Now, coming to impact in human rights, civil society, and area itself. If this amendment are implemented, the gains in human rights litigation may be narrowed down to individuals, and therefore minimizing or reducing the number of public litigations in our country. As what saying, oftentimes public litigations are litigated by those spirited individuals, and this one was repeated in the case of Mutila. Spirited individual with capacity and knowledge. Now, the recent amendments narrow down or erode the role of spirited individual, those who are knowledgeable, who have capacity not only in financial but also in terms of knowledge, procedures, and human rights, have been their space has been eroded. Now, with that situation, therefore, those who need to be represented might stay without having those individuals treated individuals like figures you have Tina, Rebecca Gumi, and others who have been filing cases on behalf of the public. Now, with this recent amendment, it's that you are supposed to show how personally you've been affected. Actually, it's like now the 26(2) is no longer in use. We are now focusing on 33. In Kenya, for instance, last year, about 300 cases on public interpretation were filed in court. But in Tanzania, we are struggling, but we don't even reach 30 cases per year. Now, with this amendment, that number might even go down. Because now, with this amendment, now the impact to NGO is that NGO can no longer. Of course, it is very hard to find a public investigation under Pradea today as an NGO. Because first of all, you are supposed to show how that particular NGO has personally affected by that particular injury or violation. So you can see that now, by 2062, previously, both NGOs as legal persons and individual as natural person had an opportunity to litigate public investigation. But with this amendment, actually the door is like has been narrowed. You have to struggle and not. You have to struggle for you to be able to get for your case to be admitted in court and prove how being as an individual or as an NGO you've been personally affected. So the issue of locus standi was not an issue previously, as what was explained by Justice Makaramba and Professor Chief. It was not an issue for 25 years. So many cases went to court, and the issue of whether you have been personally affected, if you have taken case under 2062, was not an issue. But now it is like a requirement there that you have to show that. So the impact is that we have no people or NGOs, or even lawyers who can actually bother themselves to go in court and struggle to prove before the court how personally they've been affected, why in real sense public investigation does not require. So it's just to prove you are supposed to prove according to what just for what to say in one of the cases that you are supposed to prove how you are representing the public in court of law and not how you are being personally affected. The bona fide. You are supposed to be, if you compare what Rebecca Kiumi, that's it. Let me give you an example. The case of Rebecca Kiumi, she was not married under 18. She didn't. But she had that case, not because she was actually forced to be married under 18, just because she proved before the court that she has there is a public interest. The case has public interest for all deaths in this country who cannot defend, who cannot access the court, who cannot go before the court. So there should be someone, an inspired individual, to go before the court and stand. I remember this mic, the law school mic, something. I was also a student some years ago, but not far, that's 2 years ago. So I know how they sometimes react. So now that's the case therefore. If lawyers or individuals, creators or NGOs cannot go to court and litigate for public interest litigation and litigate for human rights, that means our role of promoting and protecting human rights also goes down. Because there are so many ways of promoting and protecting human rights. You can protect through advocacy, meetings, demonstrations, and also can protect and promote human rights through court of law. Now, this wing of promoting and protecting human rights through court of law is like now is totally closed. That you cannot go, the best way, the most wise and most civilized way of defending rights, just to go is by way of litigation, through course of law. But instead of going down to court and whatever, it's a big civilized. If you take a case and defend the rights of certain people, kama alifanya Rebecca, walipofanya Kila, alifanya Wangwe, kwenye issue za wakurugenzi, na kesi zingine nyingi ambazo zinaendelea zaidi, watu wameona the best option is just going to court of law, which is more civilized way of defending rights. But now that door is like it has gone. as what Professor Chief said, it's purely an abolition of public investigation in Tanzania. Now, the proposed amendment unfortunately depart from the established maxim in our jurisprudence that the principle of public education are expressed in Constitution by investing capacity on a person and individual and as a number of community without standing to use. This important guidance offered by High Court in previous cases. Kwa hiyo impact ingine ni kwamba tayari kama alivyosema prosecutor tumeshaondoa principles ambazo zimejengwa kwa muda mrefu na mahakama zetu kuhusu public investigation in Tanzania. It's no longer there unless you get a decision of the court that might declare this amendment of the Constitution of the Badea to be unconstitutional and therefore bringing back the position that was there in relation to PIL in Tanzania. For example, take a provision in Kenya. Kenya, the relevant provision has 22 of Kenya Constitution states that every person has a right to institute court proceeding, claiming that a right or a fundamental freedom in the Bill of Rights has been denied, violated or infringed. In regard to rule, the Constitution under Article 3 give a Chief Justice power to make rules providing for court proceedings and whatever. Now, according to our procedure, for now, if you want to go to court under Bradea, the amended provision in Section 4, Article 4, you are supposed to go with an affidavit showing how you've been personally affected. That is one of the significant impacts in procedure. Some impact in whatever way you procedure nowadays it's not like it was before. Just take your related summons, you take it directly to the court and proceed. Today, you are supposed first of all to proceed with an affidavit showing how you will be personally affected. Now, this is a requirement. If you read that Bradea amendment, all provisions in number 4 in a certain requirement, and we've been doing this. Some of the cases that have been filed for post-Bradea have been going under this procedure. Now, what can we do there so far? Ni kwamba there are cases in court of law. There is a case in court of law here in Tanzania, High Court. There's also a case before regional court on the same matter, trying to request the court to see how this provision, the amendment of Bradea have offended the Constitution and therefore declaring them to be unconstitutional. So this is what we've done, and we are waiting now to see what will be the result of those court cases. But we're also doing a lot of engagement, trying to convince, doing advocacy as what we are doing right now, just to convince our authorities to see the need of amending the amended Bradea provisions, especially almost those 4 provisions, and retaining the same status that we had, and that was already positioned by decisions of the court for many years ago. We're also trying to, of course, in one way or another, it is very hard, but there's no any other mechanism what we can do apart from also telling our members of parliament that some of the laws that are going through the parliament need their scrutiny because they are there as representatives of the people. You see, some of the laws are going before the parliament, they don't get proper scrutiny of the level of the parliament, but those laws again come back and affect the people they represent. That will in brief. The amendments that were done last year has significantly affected the position of public interest litigation in Tanzania. Almost in that position, we are struggling to go through the court of law, not as it was before. But again, this also erodes the spirit of NGOs, individuals, to defend human rights through courts of law. This might also affect our academic institutions, because it has also gone to the level of amending the procedure and principles that have been taught for a number of years. The case of Utikila has been used, has been written globally, but suddenly we have a law that has a very very far position in that particular case that was decided in relation to public investigation. So that's all about the impact of Bradea and the future of public investigation. Now, quickly, because you are students of law and some of you here are advocates, currently the procedure of filing cases before the court of law with a new amendment is not quite far from what we were doing, but it's a bit tricky. That first of all, you should understand, according to Bradea rules and the Bradea Act, the procedure is you're supposed to use the orientating summons. You know, if I'm orientating summons, yeah? I think you will get this article or what I've written, the sample there. Now, previously, just having that orientating summons, and then within it, you have an affidavit, and then you are done. But now the procedure requires that you need to have that orientating summons and another additional affidavit. That affidavit has to proceed to a registrar of court for your case with legal admissions. And you have to prove you have a personal injury to whatever sort of violation that you want the court to give you the witness. When you're doing your procedure, so you need to have that matter and you go with it. If when we are that you don't have local standard, that means the end of that case. When we are you're not sufficiently proved that your personal interest in that matter, that becomes the end, because that's what the Bradea requires, that you have to prove. That's how we have some cases that will check in another, but it's good that you can keep up with nature is a personal injury, but I'm not sure if there's any case that has been taken under the name of an organization, because that's an area now becomes very difficult at some point to have an affidavit showing how an organization has been affected under 26(2). Labda kwenye ile 33 kwa sababu ni speech of individual mostly, lakini currently procedure iko more suppressed to the extent that you have to struggle before so that you can have your case admitted before the case of law. Then after that, unaendelea na procedure. Ikishakuwa admitted, you go with the normal procedure za public investigation. That you file your case, utakuwa assigned, baadaye ikishakuwa admitted, assigned 3 judges, and then later on you submit your submissions, either orally or written, and then case inaendelea mpaka mwisho. So that is the procedure. The procedure is very easy. Just take the Bradea law, the current amended law, the revised edition 2019, take the Bradea rules. There's also an article written that summarizes the procedure. That can be used to you as those students. I know you are lecturer here with teaching human rights, so that's an aspect I'm sure should be always talking to you. So on the issue of procedure, it's very key for you as law students, but also advocates who are here. Probably in the near future, they wish to establish a case on public investigation. So in short, that's all. We later on discuss even outside this forum, on how we can proceed with hearing cases by getting clearly what it's all about in terms of procedures and other requirements. Thank you.
Thank you, Nesco. Just to sum up, what we actually say is the impact of impact. And what you have to understand is that law is evolving. Law is evolving. And every generation faces their own trials. I'm sure even the Makaramba and Professor, they have many stories of actually that they can tell us how much they do and how much they fight for justice to prevail. So this dialogue, apart from just telling us that there is an issue in public investigation, but it is also testing to you that you are the future generation. If we as lawyers, if we as advocates do not see the issues in which laws are amended in a way that they ignore justice, do not take matters to our own concern, then we end up with the fact that we definitely don't trust us, and even our importance in the society will diminish. Because first of all, we have to stand for rights, the rights of the people. So we are advocates of rights. We are, apart from everything, that is something that we understand. And also, this dialogue, they teach us how they will question the things that happen in our society. How can we question and how can we solve problems that happen in our society? And that we are part and parcel. If laws are amended, they are unjust. We equally are affected. People thought that ML will not affect the ordinary people. There are many ordinary people right now in jail or in remand because of ML. So whatever is amended in our society in terms of law, we are all affected. It's not only a certain group of people. Because, for instance, if your cousins, if your brother, anyone in your village is affected, you are equally affected. So we are part and parcel of the process. That is something that we have to understand. That law is not what. Law is not what. Do we have anything to add? We have a question. Yes.
Hello? 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 Can you hear me?
Yes, you can hear me.
Yeah, I want to make two short points. One is that there is also subsection 4 of section 4, which was inserted by the amendment, which says that before seeking redress under this act, the petitioner shall exhaust all available remedies under any other written laws. In my view, this provision is also very problematic and you must find another forum and occasion for discussing it, because it does pose lots of problems. What is meant by exhausting available remedies? Because if you are challenging the constitutionality of a piece of legislation, then the only remedy is to go to the High Court. Because only the High Court or the court of law has power and mandate to declare a particular act or legislation unconstitutional. There is no other body that I know of which has the mandate to declare a law unconstitutional. So I don't know what they exactly meant by exhausting all available remedies in other laws. So I would suggest that you must find time on another day also to discuss subsection 4. Subsection 5 of the amendment of the Padilla Act, which has been inserted after the amendment. The second point I would like to make is to make an observation on what Advocate Onesmo was saying about this procedure, that first, before the petition is admitted, you have to get the registrar to admit it. My view is that even after the amendment, registrar has no powers to admit or not to admit a petition, even after the amendment. Registrar is acting in its administrative capacity. Whether or not to admit a petition can only be decided judicially, in judicial capacity. And therefore the registrar has no powers under our law to decide whether or not to admit a petition. And if that is the procedure which is being enforced, then I think it should be immediately challenged, because the registrar acts in its administrative capacity, not in judicial capacity. So I think that should be kept in mind. And finally, a quick point on the observations made by Judge Makaramba. I agree with most of the things that he said, but if I understood him correctly, this idea that the lawyers should explore other avenues, I agree with that, except that in most public law litigation, the only recourse you can have is to the courts, for the reasons that I already explained. Because, for example, maybe I did not understand Judge Makaramba well. For example, in a public law litigation, ADR doesn't apply. ADR means alternative dispute resolution. Much of the public law litigation is not disputes between parties or individual parties. It is actually, you are challenging power. You are challenging state authority. And therefore you cannot possibly resort to ADR, because you're not going to sit with Parliament to discuss, to resolve an unconstitutional law. I'm sure that's not what he meant. So ADR, in my view, doesn't apply in most of the public law litigation. It only applies in private law litigation. With those few points, I thought I should bring it on the table for further discussion on some other occasion. Thank you very much.
Thank you very much, Professor, for the presentation. There are some hands. Can you get the microphone to them?
Thank you. Having knowledge that the judiciary is the group of order for dispensing justice. Now, you see that the law to protect human rights left to advocates and these other organizations, because you can find that the strategies that are made to send cases for the declaration of this article being constitutional. Now, what are the strategies of the judiciary itself, having to know that one party that is infringing his rights, and the other party, between them, the other party, because of his power, is putting some procedural difficulties for the other party or the public to get their rights. Now, what are the strategies of the judiciary itself in removing or refraining from this backdoor interference based on the judiciary independence? Now, what are the strategies for the judiciary in the future? or can it? Thank you. Yes. Thank you. And my question is, there is this commission that is established under Article 129, that is the Commission for Human Rights and Good Governance. And one of its functions is to receive human rights updates and also execute proceedings report, that is in accordance with Section 130, paragraph E. So my question is, in the amendment, it shows that without doing this to the provision of the Commission for Human Rights and Good Governance relating to the power of Commission. So, in my view, it does not now prohibit this Commission to public interest cases. So, and now, can we rely on this as a backbone now to the cases by starting first with the Commission, and then the Commission, because it has power to cases based on public interest cases. Now the Commission now into those cases on behalf of the public.
Thank you. Just an observation, what the question, that we are discussing issues connected with the law. And if you're speaking of Bradea, now we are questioning the integrity of those who made this provision. And if we question the integrity of those who are mentioning, who put this provision in the law, it is therefore the Parliament itself. And the question in the Parliament, we are directly referring to those who composed this kind of institution. And therefore, we are speaking of individuals or the members of Parliament. And the questioning the members of Parliament, we are speaking of the parties from which they are coming from. And the questioning the parties from which they are coming from, we are questioning the public itself. What I mean, the public interest litigations has a route to trace before we are discussing them, because discussing the public interest litigations is like discussing the effect without seeing the cause. And therefore, we have to observe two things I can make. One is to prepare or understand which is an appropriate organ, like advocates, civil society organizations, who are out of this kind of interferences, and they have knowledge to understand which must be perceived as a public interest matter. And secondly, is by enlightening the public itself, because it is from this public where the lawmakers come from, and even the advocates. And therefore, the public should be enlightened enough to understand the perception or to perceive things which must be considered as of public interest. But I've been observing one thing very shortly. There are laws which have been passed by the Parliament avoiding some political medium of education in the society, for instance, for public libraries. I can submit for you. It is from this kind of public libraries where the public can get education and understand what are their rights and duties, and therefore forbidding this kind of meetings with public political parties. It is one thing of ruining the process of understanding what public litigation means. Therefore, being brief is focusing on the trade side and creating a strong, independent institution like that will get to advocate on this aspect. Thank you very much.
Asante. In fact, sina swali, nina maoni ambayo kidogo yangu. Nafikiri chanzo kikubwa cha hizi laws institution kuwa na matatizo, kuelekeza nguvu zetu kubwa kuangalia chanzo ambacho ni
bunge letu kidogo limekuwa linatupa vitu ambavyo vinaweza kuletea matatizo. Kwa mfano, ukiangalia kwenye ibara fulani siku ngapi ambayo inazungumzia kwamba ikitokea bunge likabishana na serikali kwenye bajeti ya sheria, rais atalikuta bunge. Sasa unajaribu kuangalia lengo la ibara kama hiyo ilikuwa ni nini. Unakuta kwamba wakati mwingine bunge inalazimika kuamua kitu ambavyo hata kwa wengine wanapewa kwamba havina mashiko, kwa sababu wakihofia mkate wao. Kwa hiyo kinachotokea inayoathirika kitabu. Sasa basi, nimegundua kwamba bunge lenyewe lina matatizo na katiba pia na yenyewe ina shida, hivyo inapelekea kwamba wanaoumia ni wananchi. Kwa mzuri ukiangalia swala la tozo sasa hivi wamepitisha wenyewe wabunge, lakini bado public inalalamika. Sasa unajaribu kuangalia shida ni nini. Kwa hiyo tunaweza kuzungumzia sana hizi masuala ya public interest bila kuangalia chanzo, lakini ishu kubwa bunge limekuwa na tatizo kuchukua vitu ambavyo tutasoma na kuwafanya watu. Ukiangalia kwenye swala la public interest inasema public interest. Sasa kwa nini mtu anahitajika aoneshe yeye ameumia kiasi gani? Yaani yeye kama yeye ile sio ni public interest. Sasa wabunge wanashinda kufikiria kwamba public interest ni nini. Kwa mwisho wa siku tunapata vitu ambavyo sio sahihi. Kwa hiyo ushauri wangu ni kwamba labda niangalia namna nyingine ya kufanya. Bunge pia linahitaji reform. Aidha sheria labda zilikuwa zinatungwa na mawakili au wanasheria kadhaa, katiba pia kadhaa, kwa sababu watu wanatunga sheria ambazo hazina mashiko. Kwa mimi hoja yangu iko kwenye chanzo zaidi kuliko kwenye matokeo. Chanzo zaidi ni bunge lina shida. Aidha linahitaji reform, bunge kama bunge, lakini pia katiba na yenyewe kuna baadhi ya vifungu na baadhi ya ibara haziko sawa. Kwa hiyo hayo ndio yalikuwa maoni yangu. Naomba kuwasilisha.
nguvu au nafasi ya ibara 26 ibara ndogo hii mbele ya ibara 26 mbele ibara ya 16 kwa hiyo inakuwa kinga ili kumzungumzia rais kwa kinga mtu ambaye unaona unashirikiana na public interest ile nguvu ya hiyo ibara ya 26 ibara ndogo kwa sisi kama rais tunaweza kukaa kuna vitu au vitu na tena tunakueleza sawa mtu anamulia kwa makini.
Sasa mbele ya Kristo
asante. Mimi ni jambo wakizungumzia hasa right sababu haipo kwenye zile basic rights wapatia uhuru nchi hasa kwenye kweli hilo jambo kwenye hivi katiba ya walioba walijaribu incorporate hiyo kama basic rights, lakini kwa bahati mbaya haijawa katika. Lakini sasa kwenye environmental management wamekava hiyo kama haki fulani, lakini sasa kwa namna ambavyo wameweka kwamba mfano kampuni ikichafua maji ambayo wananchi wanatumia, hiyo kampuni inakuwa faini na mamlaka husika kama neno ili wanashughulika na hayo mazingira. Sasa mfano mzuri ni makampuni makubwa kama ilivyo Barrick kwenye maeneo ya Mungu pamoja na Judiciary kule Geita. Wananchi wa maeneo ya Nyamongo, mimi nimekuwa nikifuatilia sana wakati wa sheria hii haki. Lakini sasa kwa modality ya kuweza kudai inakuwa ni ngumu sana. Lakini mwaka 2019 NEMC walitoza mgodi ule kwa bilioni 5 kwa kuchafua mazingira hasa kwenye haya maji. Na mwaka jana tena wamewatoza bilioni 5 kwa kuchafua. Sasa swali langu hapa ni kwamba mwananchi ambaye anatumia maji kwenye yale mazingira ndiye anayeathirika moja kwa moja, yeye na mifugo yake na mazao yake. Alafu Environmental Management Act inasema serikali italipwa faini, na kweli serikali imechukua faini ya fedha kadhaa kutoka kwenye huo mgodi. Sasa mwananchi ambaye yeye ameathirika moja kwa moja anawezaje akapata hiyo haki, aidha hata kwa kugawana na serikali hiyo hela waliochukua wakaenda kufanyia miradi ya maendeleo? Hasa kuna jambo umelizungumzia hapa la ADR. Je, hao wananchi wanaweza wakakaa sasa na NEMC wajadiliane namna ya kupewa basi hiyo fedha waweze kutibu majeraha walioyapata? Kwa sababu kupitia Bradea naona mazingira ni makumi ya proof direct effect, kwa sababu effect ya cyanide ina mercury zile ambazo zina extract dhahabu kutoka kwenye mchanga. Unaweza ukapata effect za moja kwa haraka kabisa, umetumia yale maji ukapata ndani ya siku mbili au wiki moja. Lakini kuna wengine inaweza ikachukua miaka mingi. Kwa hiyo option ya kusema uproof hapa ni ngumu sana, kwa kuwa serikali inakuonyesha wafaini wa tax, imewafaini wale watu na imechukua hela, inaonyesha kweli kuna uchafuzi wa hiyo hali. Sasa je, kupitia hiyo ADR ni procedure zipi wananchi wanaweza wakatumia ili waweze kupata basi kupitia kwenye hiyo hela ambayo serikali imechukua?
Asante sana. Kwa upande wangu najaribu kuweka public interest litigation katika sehemu mbili. Naweka katika narrow perspective na katika wide perspective. Mtaji wa mwisho ndio tupisha kwenye procedural matters. Nasema kwamba kuna baadhi ya kesi ziko mahakamani sasa na wamefanikiwa kuchukua course, lakini bado nao hazipo katika majina ya civil service. Sasa nijaribu kufikiria kwamba amendment ya mwaka jana imejaribu kuabolish PIL to wide perspective, kwa maana kwamba kuna watu ambao walikuwa wanaitumia hii code kufanya mambo yao, kama wazungumzaji wanaotuambia kwamba kuna baadhi labda wanasiasa wanatumia hiyo nafasi kutumia kupeleka kutumia kama kukuza interest zao kama swala. Sasa kwa nini civil societies haziko comfortable kupeleka PIL under perspective? Yaani mtafute mtu aliyeathirika moja kwa moja awe mbele, alafu wao wawe nyuma. Wanataka wao ndio wawe mbele, alafu ile mtu awe nyuma. Ni kwa nini hawako comfortable kupeleka? Asante sana.
Asante. Hii sehemu ambayo inanipa shida kidogo ni kwenye immunity
ya baadhi ya viongozi ikihusianisha na hii public litigation kwamba immunity imetengenezwa kabla wale viongozi wanaotaka immunity hawajafanyiwa chochote, lakini inapokuja kwa raia ni kwamba yeye ili afanye litigation afungue kesi mahakamani mpaka aonyeshe ni namna gani ameathirika. Sasa nilikuwa naomba, yaani nikiangalia uhusiano hapo, naona kama sheria kuna namna fulani nataka kutengeneza picha. Nilikuwa naomba comment hapo kwamba mwisho wa siku sheria inaonekana kutoka kwa jaji.
Asante. Justice Mutaramba amezungumzia kujiepusha mawakili kujiepusha na mazingira ambayo yanaweza yakasuluhika kama public interest, lakini yakawa na personal political interest. Lakini kwenye mazingira ya kawaida public interest nyingi zinapata nguvu kutokana na msukumo wa wanasiasa. Lazima kukuta kuna tatizo liko sehemu, lakini haijapata ile nguvu kwa kuwa haijapata msukumo wa wanasiasa ambao ndio wawakilishi wa ile jamii husika. Sasa swali langu ni wakati gani au ni mazingira yapi tunaweza ukatofautisha hiyo public interest lakini na personal political interest, kuachia kwamba wanafanya hivyo ili kwanza kusaidia jamii ile wanayoongoza, lakini pia ili return wanaamini itawasaidia katika maendeleo ya kisiasa. Na swali langu la mwisho, je, political interest haiwezi kuwa public interest? Asante.
Thank you. I have two questions. The first question will be to Honorable Makamba, what's the difference between division and the public interest litigation? In the presentation you gave up it's like it has two stories, but it is elaborate more. So I want to activism and the public interest litigation. That's also the case on the last contribution made by the Professor Shiki, responding to Onesimo on the last presentation there. That Professor Shiki said the registrar has no power to admit or not to admit the petition. So I want to know, with regard to the filing of cases, to look online nowadays, there are courts of law. Look online, and the registrar has the power to admit or not to admit. And if I recall well, what the Professor is saying, before and after the amendment, the registrar has no power to admit or not to admit. That has been done through the court process. So I want the court to comment. Thank you.
This right now. That's right. We take two last speakers.
Asante. Mimi na maswali mawili. Swali la kwanza, kutokana na namna mfumo wa mahakama ulivyo sasa, kwa mujibu wa katiba yetu, je, mahakama ina ujasiri wa kuamua jambo ambalo kinyume na vile jambo lolote kinyume na namna ambavyo serikali inataka? Ina ujasiri huo tayari, na kama haina nini kifanyike? Kwanza. La pili, tumsikia spika wa bunge yeye mwenyewe akisema anashangaa kwamba kuna sheria ilipita baada ya juu. Sasa nataka nisaidie. Je, hili bunge ambalo hata spika anashangaa kwamba sheria zimepitaje pale, lina uhalali wa kuendelea kujitungia sheria zingine na tukazipokea kwa ajili ya kufikiria, na kama halina nini kifanyike? Na mwisho, tunajua kuwa kuna njia mbili za kudai interest, zile haki za umma. Njia ya kwanza ni ya kimahakama, lakini njia ya pili kwa ni mahakamani. Na ipo tu sheria. Sasa hivi ukisukutu, kwa mfano, kama kuna haki za umma zimevunjwa, ukisukutu kwenda mahakamani utakutana na polisi ambao wako kweli prepared. Na kwa kweli utapigwa kipigo cha mbwa mbogo. Nimesikia polisi wakisema hayo. Na kwa hiyo watu wasukutu tena kudai haki zao kwa njia hiyo. Wamenyamaza. Lakini njia ya pili ya mahakama, na yenyewe ndio hiyo tunaona imekuwa nayo, au kama sio kufungwa kabisa. Kwa paka kufungwa kwenye boksi, lakini ana kila sababu ya kutoka nje. Sijui atatokaje. Sasa kujua na hizi njia mbili kubanwa kwa kiwango hiki. Tuna hizi haki za umma zinaweza kudaiwa. Na kama haiwezekani, nini kifanyike? Asante sana.
Ila nilikuwa nataka niulize, je, mahakama za Tanzania na ujasiri wa kuamua tuchukulia mfano kesi ya Mtikila mwaka 2009. Tumeshuhudia mahakama ya rufani inasema kwamba the issue of independent candidates is more political than real. Alafu ikaenda mbali zaidi, nasema kwamba bunge la Tanzania linaweza likaamend any article of constitution. Na sasa hivi tunashangaa bunge linaamend bara 26 bado kwa kitu kupitia Tanzania. Lakini naona tatizo lilianzia kwenye mahakama, tena mahakama ya mfano. Je, kulingana na mazingira haya, mahakama zetu siko tayari na huo akuhold hizi public interest litigation?
Sasa, maybe you can take questions from ladies.
There's a lady here.
Yes.
Oh, hello. Yeah. Yeah, right. Yeah. I think let's take this as the last question. Nadhani huu mdahalo tutaurudia wanaonesco kwa sana. Kwa hiyo
asante kwa nafasi. Nilitaka kumuuliza mheshimiwa kama watambuzi wetu katika hii kama sheria, na kwa mfano wetu hapa tukitoka, kuna watu mbalimbali wanatufuata kuwasaidia na tunayo haki ya kuwasaidia, lakini inapokuja kwa public interest naambiwa mpaka uwe umeathirika moja kwa moja, lakini unapowakilisha mteja lakini unakuwa hujaathirika moja kwa moja, lakini public interest. Sasa kama watangulizi wenyewe wa mpango huu ndio kuweza kufanya vizuri.
I think we start answering the questions which were proposed by the members. Professor, are you there? Professor Shiji, can you hear us?
I am there, yes, I am there, but unfortunately, I couldn't hear most of the questions, so they were not clear to me. Do you want me to?
Can you answer to those that you could hear?
Sorry?
Can you answer those that you could hear?
Well, unfortunately, hardly any, hardly any, but if you could repeat a summary of one or two, I could answer them.
Yes.
Can you please give me a summary of one or two questions?
Yes, there's a question of, there are many questions. There was a question whether the judiciary still has the guts to decide cases against the government. And the question as to whether the question that the speaker himself is amazed, is taken as a practice that some laws have been passed. Now, does this parliament still have the legitimacy to continue passing laws for the people? There are many other questions.
On some of the questions, those are related to some of us, and maybe for Professor to get to them. There's also a question of SHRAP. Why would we use SHRAP? Commission for Human Rights for as an avenue for public interest litigation. There is also the question of the question of Environmental Management Act. That the Environmental Management Act, though it provides the rights, especially issues of environmental rights, our constitution is silent. But at the same time, the Environmental Management Act provides a room for companies, for instance, to be fined in case of any environmental pollution or violation of environmental rights. But those money are not taken to citizens. It is only the government that takes that amount of money. Now, how is this in terms of redress of environmental? People are affected, but the government takes money. How can we rectify this problem? There's also a question of perspective. The young man here, who, according to his own interpretation, came up with two perspectives of PIL. There is that narrow perspective and wider perspective that was before, and that we've been enjoying over 25 years, using the PIL and 26.2. But in the current position, it calls it the narrow perspective. Now asking us, as civil society, why should we struggle to go to the wider perspective? Why don't we use the narrow perspective? And yet we still have, you also say that some people already are currently in court using the same narrow perspective. Why are we struggling for wider perspective that was exercised in the previous year?
I think we should first
Yeah.
Professor, do you get an overview of those? Yes, did you get the summary of some of the questions?
Unfortunately not. That's why I'm saying that if you could summarize in one sentence the question for me.
Okay.
Slowly.
Yeah, now that there was also a question. Can you hear me?
Yes, I can hear you. Can you please speak slowly so that I can hear you well?
One of the questions was also on the impact of Article 26, sub-Article 2, as regarding to Article 42. Was it Article 42? 40? Article 46. The impact of Article 26, sub-Article 2, the amendment of it to Article 46 of the Constitution, meaning that if the executive, they get immunity, and if there are people, as you said, who are mentioned, that they're not supposed to be named, that they breach the law. Now, where do those people who are affected, where do they go? Kama mhimili wenyewe ndio unakuja sheria. Sasa watu wataenda wapi kama mhimili wenyewe unapata kinga kupitia kubadilishwa kwa Article 26 na Article 2 kupitia kwa Mtadea. Sasa where do people go? Where can they seek remedy?
Yeah. There is one theoretical possibility, lakini ni kinadharia tu, kwa sababu kwa mfano kwa mujibu wa katiba yetu, the president can be impeached in the legislature for doing an unconstitutional act, among other things. But if you read the procedure for impeaching the president, it's virtually impossible to pass through those criteria. Because to be able to impeach the president, you required ultimately 2/3 majority of the parliament. And as it is, our parliament is dominated by the president's party. So that process, that political process of impeaching, is not easily available. Hence, it is important for us to realize that to be able to vindicate your rights and to be able to vindicate the Constitution, we have to struggle on two fronts. One is a legal front through litigation, but two, by mobilizing and raising the consciousness of the public of how these amendments affect them directly and how these amendments affect their freedom. Mind you, at the end of the day, judges are not angels. They also come under pressure. And one of the pressures that can be created is through a conscious public, a public which is aware. And that pressure, in my view, is one way of pressurizing the judiciary to do what it is required to do under the Constitution. But if the public is silent, if the public is not aware, and if lawyers think that on their own they can fight this battle, I think they are mistaken. And I think the experience of the last 5 years has clearly shown that lawyers alone cannot fight on the legal front. You need to open up more than legal front. You need to have a public front to be able to vindicate the rights that are given in the Constitution. And I think on that front, we have been rather weak. We have been weak because partly, and I'm not saying all, partly because our civil service organizations do not have a public constituency. They are overtly dependent on the funding agencies. And therefore, the agenda is set by the funding agencies. It is therefore extremely important for the civil service organization, for the civil society organizations, to cultivate a constituency in the public, particularly the downtrodden public. Thank you.
Professor. I think the other question to welcome is Makaranga. You can help us to tackle them and then also let's go thereafter.
Thank you. I was recording the questions. There are a total of 19 questions. 3/4 of them were directed at the young ways. I would say that we have competition. But I'll try to be support. Now, there is this question. What is the strategy? Judiciary is addressing public interest issues which arise from the amendment. Let us agree on two things. First, we have agreed as a nation that we are a liberal democracy, right? And in a liberal democracy, we have many parties. Secondly, we are a country which respects rule of law. And it is in the Constitution. Everybody is equal before the law. And everybody is below the law, not above. We will agree that it is in the Constitution. Thirdly, we will agree that we respect human rights. It is in our Constitution. We are not making it. And the last one, we are a country which respects good governance. If you have those four qualities, then what remains is to abide by those principles. Now, one thing, the judiciary is a creature of the Constitution. And the Constitution, it is the judges swear to uphold the Constitution and the law, and not to receive orders from anybody. They are the only people who take that kind of oath. The others will judges don't take that oath. They take the oath to respect the Constitution and the law, and God help them. But the rest of the people in our democracy, they say, and we shall respect the president. Now, that is where the trick is. That is, judges are supposed to be impartial, independent, in according the rule of law. And that, they are the ones who have to stand to mediate between interests of the public, the executive, and the parliament. That's why most people actually they joke, they say judges are tyrants because they are not elected by anybody, but they command everybody. And that is what we call liberal democracy. Otherwise, we go back to the time of our kings, where the king was the law. I normally make this example that King Henry VIII was so tyrannical. Actually, there was a cook who spoiled the broth and the animal juice. You know what the king said? He ordered the cook to be cooked at the temperature of the juice. No hearing, no right to defend yourself. Do you want to go there? So to agree in a liberal democracy, everybody is equal before the law. Nobody is allowed the law. Everybody should be subjected to the law. Now I leave it to you to ask yourself, do we have that kind of situation in this country that everybody is equal and everybody is under the law? Now that is, I mean, that general statement so that we can be on the same wavelength. Now the other question was the question about the broad powers of amendment. One thing we should observe, our constitution is modeled on what we call the Westminster model. We received it from England, and with the Westminster model, we have a lot of things which we do not agree. Now, our constitution still mandates that if you want to run for power, you must belong to a political party. But not everybody is a member of a political party. But we have agreed for purposes of liberal democracy, each a group that we shall have political parties on behalf of us. Now, in a democracy, once you have voted someone into power, whether on the Kura or the you have to agree with what the Constitution gives it. The problem with our Constitution is that it gives so much power to the president. Actually, Marine Nyerere was the fact that he has so much powers under the Constitution, can become a tyrant. Remember, now, the only salvation to you now, when there is such kind of a constitution, we have two salvations: the people and the courts. Courts have to be moved. Mahakama every time after case. We don't go. We are not what we call the ambulance chaser. We don't go asking you be teacher. We don't, because you will breach one of the principles of independence, 80%. So judges are also part of society. You cannot say that those who are suffering are not part of them, but you cannot go and tell them bring a case and deal with it. There was a time, and I will tell you the reason behind why we have the Bradea. Once upon a time in this country, we did not have a procedural law on how to bring human rights cases. After the amendment of the Constitution in 1984, when we were at the Bill of Rights, there was no procedural law. But people were going to court and protect Article 3 of the Constitution. And actually, that's why we have so many cases during that period upholding the human rights. You remember Justice Mwarusa. He was a sole activist, you may say, as a judge. And actually, it created a problem because people were following Mwarusanya, not the law. They would go all the way to where Mwarusanya is sitting so that they can find this. They call it forum shopping. And you can see that behavior also sometimes happening. Lawyers say that I have my judge. Nobody has his own judge. Judge is under the law. So you take case to you, you listen to the evidence and render a decision. But with that kind of situation because of what happened. Now, when the law finally we had the procedural law, what it does, what it did, actually, it went against some of the provisions of the Constitution. And then people went to court, give a time, and finally, we had the independent candidate case. And I love that decision because the judges made two critical observations. One, there is no basic structure in our Constitution. Now, what that means is that you can change any provision. Any provision. Including say, I do not know if they can say now, from today onward, we don't want the division. I don't know if they can do that. Or from today onward, we are becoming a political party, single political state. I give it to you. Say, if that. The second aspect is that they use the political doctrine question in a wrong way. The political doctrine question goes like this. If there is a matter which is purely political, it is not for the judiciary to be done. I call it. It is parliament because they are representative of the people. One of which is the question of independent cabinet. They say this is for the public to be done, not the courts. I do not know whether they were wrong or right, because that decision is still binding for us. The other thing is that the question which was asked differentiate between activism and the public interest litigation. And actually, I say sometimes people use the word activism wrong. The moment you mention activism, everybody runs for cover, as if it's someone from Mars. But what it means by activism, in the name of the judiciary, it means being proactive. There is a difference between being an activist and being proactive. But of course, there's a shortcut they use, judicial activism. But actually, it's being proactive. That is judge at your guest. It's not only the spirit of the law that letter. For example, there is a provision in the Constitution which says any law. Now, what does any law? It includes also case law. It includes customary law. It includes Islamic law. So long as it does not violate basic principles only of the Constitution. So, but what is law? It means law which is made justly. Any unjust law is not good law. I'll give you an example. In South Africa during the apartheid, all the laws were made by parliament. The procedure was fine. But there was a law which says a white man cannot marry a black. It was a law in parliament. But was it a just law? It was not, because it was discriminatory. And discrimination is in our Constitution. So in a nutshell, what I'm saying, that's what they say, we need a knowledgeable judiciary, which is robust, so that they can tackle the bull by the horns. There was, once upon a time, there was such kind of judges. Now, I'm not so sure what is happening because I'm not longer there. Now, that is another way of answering. So that's the difference. But in public interest litigation, it is what we engage in what is called dialogical activism. Dialogical activism, it involves a dialogue between the person who brings a public interest case in a court of law, the judges who are deciding that case, and whoever is involved in that process, whether it's civil society or not. That is what we call dialogical. It is dialogical activism. Finally, what comes out is a decision which brings about social change. So in a way, judges who are involved in deciding public interest cases, they are also involved in bringing social change. And that's why anyone who brings social change by legal action is called an activist. It wants to be an analogy. thinking ya activism inayotoka nyingine sema political interest, personal interest, political interest, and political interest also be public interest. Of course, the line is so narrow. What I'm saying, the test is very simple. It's the matter of great public interest. Now, it doesn't matter who is bringing up that political interest. It could be a politician. The only thing is the outcome should not be the eagerness to run for power, because politicians are always seeking power. Any politician, as you want to go to state house, where finally you want power. As any political party, you see a political party, you know, money and you say political party. Any political party seeking for power. I know it. Simple test. Now, if you bring a public interest case with an aim of assisting you in getting power, that is wrong. You should bring it because you are affected as a public leader. There's no way you can prevent you from bringing that case. The outcome is more important. But you should know that public interest litigation is a process. In a court case, in a final, it's a process. I know it involves so many things. And then there is this question. The other way of distinguishing this is ask yourself, do you want to access justice or to access power? If you want, you can answer that question, then you will know that this is the public interest. If you want to access justice for a certain group, that is public interest. But if your aim is to use public interest to access power, that is wrong. That's why we say the political interest. And then there is this issue, that's not environmental implication. And I will try to answer quickly. And actually, sometimes lawyers will struggle with what is a legal right and what is a human right. A human right is also a legal right, but not every legal right is a human. Human right and our constitution must follow what is stated in the constitution. If you read Article 37, it says any person can contest any action or any law. Now, under our constitution, any action has been subscribed because we don't allow judicial review of human rights action. That is prohibited under our constitution. Secondly, we prohibit any intended bill from being contested in our constitution. Other jurisdictions, they allow. In Kenya, you allow. Judicial review can be used as an avenue for contesting human rights. So now what you see in our system is continuously narrowing down avenues for challenging human rights violations. So that's a really serious issue, and we need everybody, not only the ADR, and they, and those who have been affected, and they see it. If you want to go to the Commission for Human Rights, you must have a complaint. A complaint is much broader than a dispute. A dispute is the final continuum when you had a conflict. You had a conflict with mining company. Then there was no solution. It became a dispute. So you had a court of action, you go to court of law, because a court of law is the only mechanism for determining violation of rights, because it is a legal right which has been abrogated. But the Commission for Human Rights can deal with every type of complaint. For example, there is a mining company which is causing pollution. It has not yet become a matter for the courts. It is still a conflict stage. Now, I shall give you an example. We had a case which actually I forgot when I was in the Commission for Human Rights. It was a resolved in Zega. There were some complaints that they violated the rights of the people whose land they had taken for mining, and they brought a complaint to the Commission. So we had to go there conduct a public hearing to hear both sides and then make a decision on who had the right to be heard and what conversation he can take. Now, in order for you to be able to use alternative dispute resolution, first, don't go to litigation. But if there is a violation of rights, as Professor Shindler said, we should have made that point very clear, it is only the courts which empowers under the Constitution. No any other mechanism. Under Article 30, Article 3, it does not suggest any other. It is only the High Court. But with now the amendments, actually, even the reference can be heard from the lower court. So yes, in order for you to deal with that complaint that will be not being compensated, you can involve the Commission for Human Rights. It will bring both of you on the table and discuss the matter and sign an agreement. The only problem you should expect that that agreement should be respected by the honored by the parties. If they can't, and this is where the Commission has the extra powers, the Commission can actually file a human rights case in a court of law. If for anything, you can bring the human rights case on your behalf. But of course, you know the problems of whether it is part of the government, it is granted and all those things. But they have those powers to also bring public interest cases before a court of law. In the Nyamura case, after the government, of course, delayed paying the compensation, they took the matter to court because under the law, it says in order to enforce the Commission's orders, you have to file them in court for enforcement. Now, the judges of the High Court, when they heard that case, they made a confusion. They thought they were to go to the merits of the case. For those among you who know the procedure of the enforcement of arbitral awards, it is very closer to that. That when you are enforcing an arbitral award, you don't go to open the merits of the case. You are only to recognize and enforce it as a court decree, so that you can now invoke the contempt of power provision if anybody refuses to execute that. But in the country of gentlemen, human rights, and respected human rights, wakipewa ile, they can actually decide to pay instead of involving the courts so that they be able to continue. Now, the other one, of course, those issues, wengine mlikuwa na moto akasema sasa bunge hili na huko nafikiri bunge hili sasa tulifanyaje? Sasa tunatoka. Now, there was this question about let me phrase it this way. Legitimacy ya bunge, parliament legitimacy comes from the people. And this is an Article 8 of our Constitution. Sovereignty, power of the people. The government for the people on behalf of them. So even parliament for the people on behalf of them. Now, if the executive and parliament messes up, there is this fair balance of the equation under the judiciary. That is, the judiciary now is the last bastion of guardian of the Constitution, has to stand between the people and the executive and the executive parliament. So those are the powers. We have agreed and gave it to our judiciary that they should be they should balance the equation. Because the power is switch. Absolute power or absolute. You should be expecting that. There are people who go beyond. So there's someone who will put them in line. Actually, the basic foundation of any modern constitution was to limit the powers of those who are in power. Now, when the powers is now affecting the financial and our votes. Well, those are the kind of things. Now, if the judiciary wants to prevent that, they should be. Now, finally, I'm winding up this by saying, I said the Constitution is the one which actually limits powers of all the other institutions. The Constitution is actually which gave the judiciary powers of check and balance. And these powers of checks and balances are very critical. You will be surprised that most people complain that it is the president who appoints the judges, and the judges are paid salaries by the state, and the judges are supposed to put the president on hold if he exercises the powers. That is the pinnacle of liberal democracy. Sasa mlikuwa mnataka majaji walipwe. Wakilipwa na wale parties, of course, anayelipwa na mkubwa simamiwa. So in order for them to be independent, tuwatunze vizuri sana, tuwape na immunity. Kwa maana huwezi kumshtaki jaji if he has decided the case, whichever way. Because in any case, there must be a winner and a loser. That is another principle of agreement. If you don't want that, you go to alternative dispute. But if you go to court, there is a winner and a loser. And actually, the other thing is that the loser should humbly agree and pay the compensation which has been determined. Now, finally, judges are also, the courts are creatures of statute. They establish under the Constitution, which means they have to respect and abide by the Constitution. So any judge, any court, worth the name, must act within the bounds of the Constitution. But any court worth the name must make sure they uphold the rule of law like anybody else. Hata jaji kuruka sheria, unaguza tu mahakama. You cannot bring up and say maybe I'm a dead and I know my baby. Some of them want to criminal, they'll bring you before another judge. Na kama ilikuwa proof beyond the reasonable doubt, you go. Sasa siku aiona kwa chini, yani kana kwa nani ugonga. Finally, for example, Michelle is telling me public confidence and trust in the judiciary. Because about that, they believe that when we take our cases to court, that matter just how fair outcome. But people wakianza kudoubt kuhusu trust ya mahakama, hawana confidence sana, watatake to the streets. Nakumbuka hicho tokea. Yeah, some leaders were saying huko mahakama we are not great. Sana mtaani. Sasa in a modern democracy, when you see people using 18th century tactics, the most weak, the weakest part of society. Wale wenye mamlaka kuweka private security wataweka, si ndio? Lakini sisi wanyonge wengi nani atatulinda? Our salvation also lies in the Constitution, the law, and the judiciary, which is impartial and independent.
Hello? Yes, most of the questions have been answered. There's a question of admissibility. That question was also asked me, but actually being responded. That you say why we are saying registrars have no power to deal with the admissibilities of applications. Of course, it makes sense that registrar are the administrative organs, but have a certain role to play in advising lawyers to follow the procedural matters of filing cases. And nowadays we are using an online mechanism, and if you don't follow the rules of procedure of filing cases, of course, your matter might be dealt with the registrar. Because they are there just that kind of procedures of filing cases. They don't go to the content. But at some point, I remember, Makarao might correct me, in election petitions, even registrar were very helpful and even supporting advocates to have proper applications. And 2015 elections was one of the elections in which the registrar played a very significant role after attending a training that was actually the trainers were the Magaramba, of course, and other judges were the trainers they received that sort of knowledge and they managed to support advocates to make proper applications and finding of cases. So at some point, we don't say that the registrars do not play a certain role in admissions and finding of cases. They have that role, but they don't go to that deep, even looking at the content now of what is finding. But the procedure now there is that you take the admission, your certificate, I mean, your certificate of admission. Of course, that's what the law says, but according to professorship, that was not the role of the registrar, and even after Radea, I mean, I think that is very clear. Now, the question that you asked about compensation of those people who've been affected by environmental pollution, why it's only named the government that takes that money? That is our role now as lawyers. To go and look that particular law, the Environmental Management Act, and if you see if it makes sense, why those heavy fines are only taken by the government, why those people who have been affected by pollution are not even compensated at any point. But when we take a case independently, we have some cases that we find where I was at the Legal Human Center. And whenever compensations are provided by those companies, they go to the public, the victims, because it is an effort of individual victims who went to court to fight against such kind of violation. But when it comes, it is an empty, whatever sort of investigation, they inform that the pollution, of course, those fines are always going to the government. I agree with you, but now that is your role as a lawyer, an upcoming lawyer. Of course, you need to go and see how you can address that matter. You now know the procedure. Just take that law. If you find that it offends any provision of the Constitution, just go through the procedure that you know. Otherwise, I think most of the questions have been asked. And the question of why civil society? Why are we struggling to use the previous mechanism, the wider perspective of going through course of law and not using the current procedure, which requires a certificate, I mean, a affidavit of an experience. The issue is, if you have a door and then you have a window, if someone tells you to go to come through this hall, through the window, and instead of using the door, what kind of logic do you get there? There's some people not be able to go through the window. It's very hard to go through the window than going through the door. So the issue is the current amendment ni kama vile inalazimisha watu waende mahakamani kwa njia ambayo ni ngumu sana. And that some people may not be able to do that. Ndio maana tuna struggle kurudi kwenye mazingira yale. Imefanya watu wachache ndio wataweza kwenda kwenye njia ile. Wengine hawataweza. You see? So it makes only few people individual who can start. Hapo wanaweza kushowcase, wanaweza kuprove that the impossible wanaweza kufanya. Ukienda kule inapigwa PO kwamba huyu hana personal, na kesi nyingi sasa hivi PO zinakuja namna hii. Kwamba you don't have personal interest. Why should you find this case when you don't have personal interest? Sasa hiyo ni sawasawa na kwamba tunataka sasa mtu awaze kufikiria hii kesi bana, waliokuwa evicted ni watu kule na Tarime. So why should I bother here in Dar es Salaam? It's not like, how can I tell the court? How am I affected? Niko Dar es Salaam, and there are some communities in certain districts who are affected, and I want to open a case on their behalf. Na ilipeleka kiumbe leo angekuwa anajiuliza, angeuliza wewe una affect you, mbona wewe ni mtu ambaye you are tayari kwenye bereji yako, umesoma, na ni why you are affected. How are you affected? Angeshindwa kuprove ile kesi. Naona hii mbinu kachukua sasa, labda msichana wa kule aliyeolewa akiwa na 18, which sometimes is very difficult. Watu wanaogopa. Kuna watu ambao ndio maana nani amesisitiza hata kusoma zile tisio jaji kwa kwati ni kwamba kuna watu wao wanaweza kawa wana kila sababu ya kwenda mahakamani, lakini hawawezi ku access court. Kuna fear, kuna capacity, kuna knowledge. Mtu mwingine anasema, mimi kaishitaki serikali. Wewe unachukua mtu mwingine kule anaanza, how can I go? Lakini wewe unaweza kwa sababu you know the constitution, you know the law, unaweza ukastand on behalf of them. Ndio maana tunasema sasa ni muhimu turudi kule. Vinginevyo itakuwa ngumu sana kupata education. Tungeti. Asante.
I just want to congratulate you for your patience and for your eagerness to get knowledge. We're winding up, and I would like to welcome the Vice President of the Law School of Tanzania, Mr. Karimu Soliamlimu, for some closing remarks.
Dear respected speakers, program coordinators, land advocates, advocate candidates, and all media representatives in this room, good evening. I myself, on behalf of the President of Tanzania Students Bar Association, TASPA, and the students of Law School of Tanzania in general, would like to extend this heartfelt honor and gratitude to the coordinators of this platform. It was an enjoyable. The coordinators from THRDC, the Tanzania Human Rights Defenders Coalition, in collaboration with the American Bar Association. We thank you very much. It was an honor for sure to have this opportunity and platform, passing through the subject on public interest litigation. We wish to still have you on some other times. Thank you very much.